In your ruling, the Second Circuit ruling on, and I'm trying to remember the name of the case, Maloney, the position is that there's not an individual fundamental right to bear arms in this country. Is that a correct understanding of that?
No, sir.
Okay. And please educate me if you would.
In the Supreme Court's decision in Heller, it recognized an individual rights to bear arms as a right guaranteed by the Second Amendment, an important right, and one that limited the actions the federal government could take with respect to the possession of firearms. And in that case, we're talking about handguns. The Maloney case presented a different question, and that was whether that individual right would limit the activities that states could do to regulate the possession of firearms. That question is addressed by a legal doctrine. That legal doctrine uses the word fundamental, but it doesn't have the same meaning that common people understand that word to mean. To most people, the word by its dictionary term is critically important, central, fundamental. It's sort of rock basis. Those meanings are not how the law uses that term when it comes to what the states can do or not do. The term has a very specific legal meaning, which means, is that amendment of the Constitution incorporated against the states?
Through the 14th Amendment.
Through, and others, but generally, I shouldn't say and others, through the 14th. The question becomes whether and how that amendment of the Constitution, that protection, applies or limits the states to act. In Maloney, the issue for us was a very narrow one. We recognize that Heller held, and it is the law of the land right now in the sense of precedent, that there is an individual right to bear arms as it applies to federal government regulation. The question in Maloney was different for us.
Okay.
Was that right incorporated against the states? And we determined that given Supreme Court precedent that had addressed that precise question and said it's not, so it wasn't fundamental in that legal doctrine sense, that was the court's holding.
Did the Supreme Court say in Heller that it definitely was not, or did they just fail to rule on it?
Well, they failed to rule on it. You're right.
There's a very big difference there.
I agree.
Okay. Let me continue with that. So I sit in Oklahoma in my home, and what we have today as law on the land, as you see it, is I do not have a fundamental incorporated right to bear arms, as you see the law today.
It's not how I see the law.
Well, as you see the interpretation of the law today, in your opinion of what the law is today, is my statement a correct statement?
No, it's not my interpretation. I was applying both Supreme Court precedent deciding that question and Second Circuit precedent that had directly answered that question and said it's not incorporated. The issue of whether or not it should be is a different question, and that is the question that the Supreme Court may take up. In fact, in his opinion, Justice Scalia suggested it should, but it's not what I believe. It's what the law has said about it.
So what does the law say today about the statement? Where do we stand today about my statement that I claim to have a fundamental, guaranteed, spelled out right under the Constitution that is individual and applies to me, the right to own and bear an arm? Am I right or am I wrong?
I can't answer the question of incorporation other than to refer to precedent. Precedent says,
I
as,
understand.
as the Second Circuit interpreted the Supreme Court's
I understand
precedent, that it's not incorporated. It's also important to understand that the individual issue of a person bearing arms is raised before the court in a particular setting.
Context, yes.
And by that I mean, what the court will look at is a state regulation of your right,
Yeah.
and then determine, can the state do that or not? So even once you recognize a right, you're always considering what the state is doing to limit or expand that right, and then decide, is that okay constitutionally?
Yeah, it's very interesting to me. I went back and read the history of the debate on the 14th Amendment. And for many of you who don't know, what generated much of the 14th Amendment was in Reconstruction. Southern states were taking away the right to bear arms by freedmen, recently freed slaves. And much of the discussion in the Congress was to restore that right of the Second Amendment through the 14th Amendment to restore an individual right that was guaranteed under the Constitution. So one of the purposes for the 14th Amendment, one of the reasons it came about is because those rights were being abridged in the southern states post-Civil War. Let me move on.